1, 2, 3, start. Legally, an agreement to sell may not be regarded as a transaction of sale or a document transferring the proprietary rights in an immovable property, but the prospective purchaser, having performed his part of the contract and lawfully in possession, acquires possessor title which is liable to be protected in view of section 53A of the Transfer of Property Act 1882. The said possessor rights of the prospective purchaser cannot be invaded by the transferor or any person claiming under him. Notwithstanding the above, as the plaintiff respondent admittedly was settled with possessor title in part of performance of the agreement to sell dated 10/4/2002, and that the defendant appellant has lost his possession over it and had acquired the right of possession under a license, simpliciter exhausted his right to continue in possession after the license has been determined. Thus, the defendant appellant parted with the possession of the suit property by putting the plaintiff respondent in possession of it under an agreement to sell. The plaintiff respondent in this way came to acquire possessor title over the same. The defendant appellant as such ceased to be in possession of it as an owner, rather occupied it as a licensee for a fixed period which stood determined by valid notice, leaving the defendant appellant with no substituting right to remain in possession of the suit premises. In view of the aforesaid facts and circumstances, the plaintiff respondent has rightly been held to be entitled for a degree of eviction with mean profits. We do not find any error or illegality in such a decree being passed. Accordingly, the appeals lack merits and are dismissed with no order as to cost. Thanks for watching.